This is a sneak peek into my most recent Real Estate 201 seminar. A scammer, a divorcee, and an executor walk into a bar. If you missed it, this is going to talk to you about one of the sections. Don't forget to sign up so that you can watch live with us next quarter. We do them quarterly. And without further ado, this is the section about the divorcee. You know, we've all probably at this point dealt with transactions with parties that are getting divorced. And here's the fact summary. A couple bought property while they were married. Cool, normal. Later, they get divorced. Also happens quite often, but here's where things get a little bit different. They continued to own the property together. No changes to the deed. Buying the property as Joe and Sarah, husband and wife. They get divorced. They're no longer husband and wife, but Joe and Sarah still own the property. Before we get into the way this can go sideways, let's talk about different types of ownership. So you've got joint tenants with rights of survivorship. So that's a way that you can own property together so that if one person passes away, the survivor will receive the property completely at that person's death without requiring any sort of probate. Next thing, tenants in common. This is if you own, this is the default. So if you don't specify rights of survivorship or your marital status to get the tenancy by the entirety, then this is what your ownership will be. And this means that any person's share in the property, if you pass away, it doesn't automatically go to the other owners. It goes to that person's heirs. And then finally, tenancy by the entirety. This is a way that only married couples can own property in North Carolina. And it has some of the same features of rights of survivorship in that if one spouse passes away, the other one will own the property 100%. And then also it's protection from individual creditors. So this is kind of a way to protect the marital home. Say, husband gets judgments against him, and this prevents them from attaching to property owned as husband and wife. So you'd have to have a judgment against both husband and wife for that judgment to attach to the property if it's owned in this manner. Now, in this case, the owners took title as husband and wife, which means they had tenancy by the entirety, and then they got divorced. So what happened then? When you get divorced, the tenancy by the entirety protection is severed. So you no longer have the survivorship element or the protection from individual creditors. So you have now become tenants in common unless you were to redo the deed and specify rights of survivorship or something. That didn't happen in this case. So this now ex-husband and wife became tenants in common. Now, the next question is, well, what if there are judgments? This happened. There were judgments, and it was the husband. The ex-husband had about 5 judgments against him. Like we said earlier, once the tenancy by the entirety is severed, whether that's by a deed, a final divorce decree, or whatever it may be, upon becoming tenants in common, those judgments attached to the property. And because this ex-husband had those judgments, all of those judgments had to be paid before the property could be sold. Now, the parties, they didn't even think about this. They thought, okay, well, we broke up, we own the property together, so I shouldn't be worried about what he's doing individually, but they should, in fact. This did not happen, but it's important to know, since these folks got divorced, what if there are new spouses? So in this case, we've got a man and a woman who are married or no longer married anymore. If they each remarry, we have gone from 1 to buy, 2 to sell, from 2 to buy, and 4 to sell. So if either of those people got married, then their spouses would also have to sign in order to sell. And that might prove difficult if we've got some uncooperative new spouses and that don't like the scenario. So that definitely complicates things. And at the end of this scenario, let's talk about who signs and what about those judgments. Now, the easiest answer is about the judgments. In all scenarios, the judgments have to be paid. They attached once those folks got divorced. And in fact, in this scenario, the husband continued to rack up more judgments past that date. So they all had to be paid before the property could close. But as far as signing, there were no new spouses. It was just the original owners. That made it fairly simple as to signing. Just the original owners had to sign. No spouses to have marital interest, no heirs, thank goodness. In the case of remarriage, that would be the original owners and their new spouses, unless, one of the original owners and their new spouses had a prenup, a postnup, a free trader, or the new spouse gives up their marital interest by virtue of a deed. So it's got to reference the proper statutes. You got to be giving up your right to share in the spouse's estate as to that property. It is not as simple as just pulling a deed off of the internet. You guys should know that. I think you know that. It's not as simple as that. Well, I really appreciate you guys. Thanks for taking the time. If you have any follow-up questions, please let us know and let us know about topics for next time. Otherwise, we'll just be minding real closings, and we'll talk about some more real closings next quarter. See you then.